Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the immigration, medical malpractice, and business litigation law firm Kurzban, Tetzeli, and Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by EB5 Support. Not sure what to do when a client asks you about the EB5 investor visa or how they can choose the right EB5 project? That's where EB5 Support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB5 Support helps investors navigate the entire process of EB5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everyone. Wonderful time to be alive. I still haven't got an email about awesome wins from the podcast's patrons. Give me something, guys. I know you got something. This week, among other news, the district court judge denied the Department of Justice's request for an emergency stay of our Haiti TPS win. At the end of that very long and interesting hearing, the judge read into the record some of the truly horrific sexual type and death threats that she has been receiving since interpreting the text of the INA last week. Also, I received this email from a longtime listener, In the Know. The listener writes, "Greetings, Kevin." Greetings. I just listened to your summary of Matter of Loren Castro. Episode 301, by the way, and I feel like the BIA was kind of misleading in their decision. Okay, I'll stop with the first person now. First person, right? Anyway, the writer explains how the IJ didn't actually reset the case a second time in November, and how it was reset by someone else because the IJ got fired, and how the matter was actually only continued by that first IJ once, and how all of this mess kind of happened because of EOIR's rash of firing judges. Also, the writer believes that the BIA made it seem kind of like the IJ hadn't really articulated a reason for continuing, rather than entering an in absentia removal order. But to the contrary, it was the IJ's practice after the courthouse arrests started last summer to state on the record that the IJ was continuing because of increased ICE enforcement actions, which were causing the doors downstairs in the courthouse to be closed, and sometimes there was no guard to even let respondents in. That sounds like an important thing, and I don't know why the BIA wouldn't have put that into its published decision. And it all sounds like to me that the IJ was trying to protect due process violations from occurring, but that's just me. The writer is dismayed by what appears to be a somewhat calculating and manipulative BIA decision-making intended to make immigration practice quite cruel and scare those IJs who remain on the bench. Hard to argue with that. If you want to argue about it, shoot me an email. As this intro makes clear, I'm down to relay emails on the podcast. Here are 3 decisions for you all. I've gone deep into all of them because, well, there's only 3. Our first case is Rene Lopez v. Bondi, published by the 4th Circuit on February 13th, 2026. This case is about U.S. citizenship and who gets it. Not the horrifically sexy kind currently at the Supreme Court, no. The wonky, statutory kind that depends on unwed parents and paternity by legitimation, or lack thereof. Let's dive in. Mr. Lopez was born in El Salvador in 1981. His parents weren't married, but his father, Mario, signed the birth certificate. Mario was never in Mr. Lopez's life, though. At 11 years old, Mr. Lopez was admitted into the United States as a lawful permanent resident to live with his mother. And while living with her when he was 16 years old, his mother naturalized to U.S. citizenship. Under the old statutory framework for citizenship, applicable at the time, Mr. Lopez became a citizen when his mother did, so long as paternity had not been established by legitimation at that time. That's the only legal issue. Did Mario establish paternity by legitimation at the time that Mr. Lopez's mom naturalized, when Mr. Lopez was under the age of 18? Pretty important because Mr. Lopez committed drug crimes that got him 10 years imprisonment and surely makes him removable if he's not a U.S. citizen. But he is, explains the 4th Circuit, overturning a very long and complicated history of immigration judge and BIA decisions in this case. By the way, Mr. Lopez is currently rotting in immigration detention, has been doing it the whole time. Something completely illegal given that he's been a U.S. citizen the whole time. I imagine he was released on Friday, immediately? I should hope so. Astonishing, though. Before we get to whether this man's a U.S. citizen, the 4th Circuit had to conclude that it could review this issue at all. There were, after all, multiple IJ and BIA orders and multiple instances of finding him removable and denying Convention Against Torture protection. It's very complicated and worth a review in the 4th Circuit if you fear you have a Riley-type petition for review issue that Supreme Court decision talked about last term. So give this a read in the 4th Circuit if you ever have, say, an IJ removal order and a BIA remand for Convention Against Torture analysis only. At the end of the day here, because an IJ ultimately reopened the prior removal order and issued a new removal order, and then that was affirmed by the BIA, that superseded the first removal order, explains the 4th Circuit. As Mr. Lopez petitioned for review to the 4th Circuit within 30 days of that BIA affirmance, that's permitting review here. It's very complicated, and I am summarizing pages and pages of analysis. It's really for the most into-the-weeds 4th Circuit petitions for reviewers, and so you need to review it if you have a procedurally complicated case and are going to the 4th Circuit. Know this, though. On jurisdiction and the 30-day rule to petition for review of final removal order, the court held that Riley implicitly abrogated its 2019 decision, Coambo v. Barr. Also, write me if you disagree, counsel, but I think the big takeaway in other cases will be that the 4th Circuit is saying that after Riley, if you get a remand from the BIA for further withholding of removal and or Convention Against Torture analysis, you have to petition for review within 30 days the BIA's denial of asylum and all other challenges to denied relief and the removal order, even while you're simultaneously litigating withholding of removal or Convention Against Torture protection below before the immigration judge. Tell me if I'm wrong, but I don't think I am, given footnote 4. That rejects the private bar's attempt since Riley to distinguish the Riley rule from removal proceedings in chief because Riley arose in the expedited removal or Farrow context, if I'm recalling. Complicated stuffs. And the Fourth Circuit implied it might stay the initial petition for review to wait for the withholding of removal and cat stuff to play out in cases like this. Might. Be warned. That's really Riley's fault, though. Blame it on the Supreme Court. A generally good motto in many contexts these days. All of that just to decide the fairly straightforward question of whether the man's father legitimated him. Something most people would want in the real world, but not in the old immigration derivative citizenship world. It's all going to be moot one day, given that this particular statute was repealed in 2001 and replaced with a less weird one. But heck, it still applies to even elder millennials like Mr. Lopez and yours truly. So it is, of course, highly worth noting and very important. Now remember, the father did sign the birth certificate, right? Well, quote, the question is not whether the identity of Mr. Lopez's biological father was known when his mother naturalized, or whether his birth had been deemed legitimate, as opposed to illegitimate, for some, or even all purposes. Instead, the question is whether Mr. Lopez's paternity had been established by legitimation, end quote. To the Fourth Circuit, that means legitimation must be the means by which paternity is established. It's a verb. So WTF is legitimation? Well, the Fourth Circuit doesn't conclusively answer. But it does hold that merely signing a birth certificate isn't sufficient. And it also holds that legitimation requires an actual act. Now, to support this case, like the BIA before it, Oyl provided a, quote, exegesis of Salvadoran family law, end quote. Can't blame them. Seems kind of important to show what El Salvador considers to be legitimation, right? Well, not really to the Fourth Circuit. It may be true that children born to unmarried parents now have the same rights as those born to married parents in El Salvador, or that signing a birth certificate in El Salvador is in fact sufficient to acknowledge paternity in that country. Maybe. Doesn't matter to the court. Whether paternity had been established by legitimation is a question of U.S. law. Even if paternity was established here, it didn't happen through legitimation. By the way, to the extent the government argues that in your circuit, a different rule applies that hurts your client, quote, each case the government cites had materially different facts, interpreted materially different statutory language, and or was decided before the Supreme Court instructed federal courts not to defer to administrative agencies like the board about questions of statutory interpretation, end quote. The Fourth Circuit spends some time going through those decisions, so check it out. And to me, makes quite clear that no matter stare decisis implications within a circuit, an out-of-circuit decision that relied on Chevron deference probably isn't worth that much after Loper Bright. And to the contrary, the Fourth Circuit believes that Rene v. Bondi is in line with its decision here, almost directly on point. Episode 270 out of the Second Circuit. And reading my summary of that decision now, well, indeed. Here's Oyl's real point, quote, the government represents that many jurisdictions, not just El Salvador, have abolished the traditional legal distinctions between legitimate and illegitimate children and have also eliminated any legal mechanism for establishing a child's paternity by legitimation, end quote. So if there's no process to legitimate, people like Mr. Lopez will always win and always be derivative citizens under the Fourth Circuit's rule here. Maybe so. But, quoting Ms. Chavez and other Supreme Court precedent, the Fourth Circuit reminds that, quote, it is never our job to rewrite a constitutionally valid statutory text under the banner of speculation about what Congress might have done had it faced a question that, on everyone's account, it never faced, end quote. We are all textualists now, I believe Justice Kagan recently quipped. The text wins for Mr. Lopez, and many like him. Our man's a citizen. And so, congratulations Benjamin Osario for petitioner, along with many others on briefs. Man, these derivative citizenship cases take forever to read. And as if you needed more, In reaching this holding, the Fourth Circuit wonders aloud whether the whole framework wherein naturalization applicants have a heavy burden to prove citizenship, and where all doubts are weighed in favor of the government, whether that actually applies to derivative citizenship cases. It might not. That's more about naturalization. Reasons the Fourth Circuit out loud. That itself is important to remember, folks, so remember it. Relatedly, the court very much makes clear that when the only question is a legal one, that is, the legal significance of agreed-upon facts, burdens don't matter. That, to me, seems very important to realms far beyond derivative citizenship, including, say, the categorical approach cases that turn on legal issues, as opposed to categorical approach cases that turn on factual disputes, like was the case in the Supreme Court's Pratt decision from a few terms ago. And that is Rene Lopez v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.thepen-and-swordkc.org or at the special links in the show notes. Use special code ImmigrationReview26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. Moving on to matter of Jin, published by the BIA. This case is about I-130 petitions. Revoking them, of course. Like so many BIA decisions of late, the BIA explains that it almost never takes cases in this procedural posture, but it will do in this case, which happens to be quite bad for non-citizens. This is a necessary exception. USCIS approved an I-130 petition filed by Ms. Zhang for her husband, Mr. Jin. Ms. Zhang is a U.S. citizen. Her husband is not, and is from China. USCIS also approved the husband's I-485 application, making him a conditional lawful permanent resident based on the fact that him and Ms. Zhang had been married for less than 2 years when the petition was filed. Shortly after that, the couple separated. Then the petitioner, Ms. Zhang, filed a petition to annul her marriage based on fraud. Which seems like quite the important fact right off the bat to distinguish this case from nearly all others. They didn't just divorce. She annulled the marriage from the start and said that fraud was the basis. Anyway, over 2 years after the I-130 was approved, and with the husband already a conditional lawful permanent resident, Ms. Zhang appealed the I-130 approval, seeking its denial. Something I imagine never happens, and certainly not in such an untimely fashion. But happened it did, and sustained the appeal. The BIA did. Ms. Zhang claimed she was a victim, and so I assume that she legitimately loved Mr. Jin and thought the marriage bona fide. He didn't, she argued. Quote, the petitioner has submitted hundreds of pages of evidence to support her assertion that the beneficiary fraudulently induced her to marry him, and thus their marriage was invalid. The submitted evidence includes 19 detailed affidavits, a petition for annulment based on marriage fraud with the beneficiary's related deposition transcript, police reports, and medical records, among other documents. End quote. In a footnote, the BIA acknowledges that the couple have a child together, and I don't need to tell you what that implies. But Ms. Zhang asserts that Mr. Jin abandoned her shortly after she gave birth and that he doesn't support the child. But I think it worth more than a footnote? What do I know? The BIA begins by stating that, quote, marriage fraud has been a long-standing problem for many decades and remains a serious issue in the immigration context,
end quote. A page worth of citations there. When determining marriage fraud, explains the BIA, quote, key to this inquiry is determining the party's intent at the time of their marriage, end quote. Not what happened later or how good the marriage was, but what the parties intended when they said, I do. That's all that technically matters. But of course, after-marriage actions can shed light on that intent, explains the BIA. Sometimes USCIS does interviews, but they didn't do that here. Quote, petitioner raised valid concerns about this practice, end quote. So what? Ms. Young wanted an interview so her husband's fraud could be exposed to her? Sounds like counsel with an agenda has concerns about this practice. In any event, explains the BIA, when fraud is indicated, the whole matter goes to FD&S for further investigation, including potential home visits. And don't forget that fraud is presumed where the marriage occurs during the pendency of removal proceedings. Robustly support your I-130 filings, guys. None of that happened here, of course. And as the BIA explains, as an appellate body, it cannot fact-find. And plus, USCIS can always revoke an I-130 petition, and the Supreme Court's Boarfa decision says that will not be subject to federal court review. Not to mention, Mr. Jin will have to come back to USCIS to get the condition removed, explains the BIA, where all of this new evidence, if submitted to USCIS, would be very important and surely ruin his ability to become a full-fledged LPR and may very well lead to his removal. And there's possibly even rescission proceedings, continues the BIA, outlining all the ways immigration law can screw lawful permanent residents. And it's all true. And then all of this will lead to an INA Section 204C finding that will permanently bar another petition from ever being approved for Mr. Jin, if what Ms. Young is saying is true. So why is Ms. Young's counsel submitting this new evidence to the BIA instead, and through the vehicle of a very late-filed BIA appeal? Is it an attempt to get the BIA to issue a precedential decision harmful to non-citizens? The BIA has obliged, going full-on policy entity if you ask me, quote, while these avenues to uncover marriage fraud exist, this does not mean they are adequately utilized by DHS. As noted earlier, marriage fraud has been a serious problem in the immigration system for many decades and remains a serious issue today. The petitioner makes strong policy arguments that USCIS does not devote adequate attention and resources to uncovering and addressing marriage fraud. However, the board cannot direct USCIS or supplant its role in the system, end quote. What are we even doing here, guys? What is the BIA today? All of this policy stuff leaves less than 1.5 pages of analysis in this 10-page decision. DHS actually opposes the appeal in this case. But the BIA notes that Ms. Zhang cites to 8 CFR Section 1003.1D3 which provides that, quote, the board may review de novo all questions arising in appeals from decisions issued by DHS officers, end quote. Nothing about the untimeliness, though. Now, the BIA recognizes it has to return the case to USCIS and can't just revoke the I-130 approval. In no small part because Mr. Jin was not even provided an opportunity to respond, given that beneficiaries are not parties to I-130 petition review. Those are the petitioner's cases, the petitioner's form. Mr. Jin quite literally has no idea what's going on, with a Section 204C finding and removal proceedings dangling over his head. But, deeming the evidence of fraud extensive and footnoting the child of the marriage, the BIA sent the matter back to USCIS for evaluation. USCIS can inform Mr. Jin, notes the BIA. Unclear to me what new law was broken here to require a precedential decision, other than I suppose the BIA indicating that it is very open to untimely appeals of I-130 petition grants. Hey, for what it's worth, the BIA declined Ms. Zhang's counsel's request to use this case as a forum for the BIA to revisit its marriage fraud precedent, surely in a manner adverse to non-citizens. Footnote 10. A bit more, because it all seems quite strange to me. Thanks to an email from some of you in the community, I looked up Ms. Zhang's counsel, who sure does seem to have an agenda. But let's be honest, we all do, right? We all do. Well, anyway, it appears, colleagues, that there are attorneys in the immigration bar who, quote, Unlike traditional immigration, attorneys do not represent foreign nationals. This ensures our duty of loyalty is undivided, and our strategies are shaped solely by the interests of U.S. citizens." End quote. Who knew? I can't believe that my duty has been divided all of these years. Quite the website, too. And here's some stuff from the attorney's review section that, as the website explains, features AI images of the clients. Quote, "Read how we helped Nicole secure a final order of removal of a foreign spouse who committed marriage fraud and forged a joint I-751 petition, thereby eliminating her I-864 liability." End quote. Or quote, "Read how we helped Katie achieve what may be the first successful BIA fraud appeal of its kind, leveraging an annulment to stop the green card process in its tracks." End quote. I imagine today's decision will also make the cut. And that is Matter of Gin. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. We conclude with Buenrostro-Mendez et al. V. Bondi et al., published by the Fifth Circuit on February 6, 2026. All right, fine, guys, I'll do it. I didn't want to do it, but I said I'd do it last week. But I really don't want to do it. Not only is it just so dense and complicated, but it's cruel. Plus, I expect a circuit split will soon develop, and I'll be doing the decision again soon, perhaps with the analysis urged by Judge Douglas in dissent. Indeed, based on a footnote, it seems like things are already bubbling up in the 7th and maybe 9th circuits. But Judge Jones has a 2-judge majority here, so thousands will be incarcerated without bond in the 5th Circuit, where the majority of immigration detention centers are located. As I mentioned at the top of last week, the Fifth Circuit has essentially affirmed the BIA's unique interpretation of the expedited removal and mandatory detention provisions in matter of Hurtado. The non-citizens here entered the United States without authorization years ago. They've built lives in this country. There is no allegation that they are bad or dangerous people. The U.S. government seeks to detain them without even giving them the opportunity to show that they are not dangerous and not an irremediable flight risk. The Fifth Circuit has blessed that. We'll go through the analysis in the way the Fifth Circuit majority does. Before the 1996 IRIRA changes to immigration law distinguished between non-citizens present at a port of entry and those who entered without authorization. Those who arrived at a port of entry were placed in exclusion proceedings and subjected to mandatory detention. Those people are applying for admission in the United States from abroad. Those who entered without inspection, or EWIs in contrast, were placed in deportation proceedings, and they could get a bond hearing, and they could get released if a neutral arbitrator agreed by looking at the facts of their case, by treating them as human beings. IRIRA funneled everyone into removal proceedings, though. The Fifth Circuit also explains that Congress sought to, quote, reduce this incongruity, end quote, and thereby decreed by statute that even EWIs, quote, shall be deemed for purposes of this chapter an applicant for admission, end quote. That statute is I&A Section 235A1. And at I&A Section 235B2A, Congress provided for the mandatory detention of applicants for admission, explains the Fifth Circuit. The applicant for admission exception, explains the court, are non-citizens subject to subsection B1, which is the expedited removal framework, and those people are also getting detained for other reasons. Now, DHS can, of course, be nice and parole out whoever they want, but when they decide to be cruel across the board, as is currently occurring, there's nothing courts can do about it. Essentially, explains the Fifth Circuit majority. Continuing on. The I&A has provisions for detaining most everyone else that requires, quote, a warrant issued by the Attorney General, end quote, now interpreted as DHS. That's I&A Section 236A, and it allows for release on bonds of at least $1,500. It also doesn't explicitly exclude applicants for admission. They could be included under 236A. And all of this is, of course, putting aside I&A Section 236C, which is criminal-type mandatory detention. For almost 30 years, presidential administrations, including Mr. Trump, treated EWIs as subject to I&A Section 236A, meaning they got bond hearings. But then the BIA changed things last year in the matter of Hurtado and explained that actually, very smart people have been wrong for 28 years. And the gloves came off. Quote, since DHS began to detain unadmitted aliens under Section 235B2A, well over 1,000 non-citizens, I'm going to say that, not aliens, have filed habeas corpus petitions seeking bond hearings. In most of these cases, the district court found in favor of the petitioner, end quote. No longer in the Fifth Circuit, decrees the majority. So again, we've got two dudes from Mexico without criminal histories who EWI'd and who have been here for decades. Mandatorily detained in 2025. Both got bond hearings after filing habeas petitions, and both got released from immigration detention, presumably to be with their families. For no reason specific to them, it looks like they will again lose their freedom. The non-citizens concede here that they are applicants for admission within the meaning of I&A Section 235A1, and that they were present without inspection or admission when apprehended. Quote, presence without admission deems the petitioners to be applicants for admission, end quote. To the Fifth Circuit, though, the non-citizens and all the amicus argue that Section 235B2A mandatory detention only applies to applicants for admission who are seeking admission. That is, applicants for admission at the border, or perhaps caught very shortly after entering. Thank you, Thoracicum. And that argument is based on the text of Section B2A itself, which expressly applies only to those seeking admission. Quote, pointing to a definition of admission at I&A Section 101A13A, the petitioners contend that admission means the lawful entry of the non-citizen into the United States after inspection and authorization by an immigration officer, end quote. And that is not what is happening here with EWIs. But the court disagrees that that is what an applicant for admission means. Based on how it reads the text of the mandatory detention statute, quote, there is no material disjunction by the terms of the statute or the English language between the concept of applying for something and seeking something, end quote. So an applicant for admission to the Fifth Circuit majority is always seeking admission. The court goes on for a few pages explaining this and the interplay with other I&A provisions, analogizing to people applying for college admission. And the court believes that EWIs are, quote, seeking admission, end quote, the entire time they're in the United States, no matter how long they've been here. Now, maybe this interpretation makes other portions of the I&A redundant. Maybe, explains the Fifth Circuit majority, but that doesn't give it the right to rewrite the statute, explains two judges on the court. At the end of the day, in the Fifth Circuit, quote, an applicant for admission is necessarily someone who is seeking admission, end quote. Also, explains the court, if Congress wanted to limit all of this to arriving aliens at the border, as it believes the non-citizens are essentially arguing, it could have made that very clear in the statute. The non-citizens then made a Laken Riley Act argument, something we've all been making now for like a year, right? Recall the Laken Riley Act last year made certain EWIs and others subject to mandatory detention? Not all of them, but only some of them. Why do that, asks the non-citizens very persuasively, if Congress believed its statute already made all EWIs subject to mandatory detention? The Fifth Circuit answers that by saying it seems that Laken Riley still does work by eliminating the possibility that DHS can parole such non-citizens, which I will admit is a take I have not heard anyone else say about Laken Riley, and also which I don't think is accurate. Can't DHS parole anyone they want? But also jumping right into policy, quote, Congress passed the act at a time when the executive was still declining to exercise its full enforcement authority under the INA. Accordingly, the act did have a substantial effect when passed, insofar as it required the detention without bond or parole of certain non-citizens the administration was then treating as bond eligible, end quote. This is all going to go to the Supreme Court, so the Supreme Court's recent Jennings v. Rodriguez decision seems quite important. The Fifth Circuit majority believes that all of this aligns with Jennings, even though there's a passage of that decision that seems to distinguish between aliens seeking admission and aliens already in the country. Dicta, pretty cursory, and not necessarily contradicting, explains the Fifth Circuit. As to 28 years of executive interpretation in the opposite direction, quote, years of consistent practice cannot vindicate an interpretation that is inconsistent with the statute's plain text, end quote. On this, the Fifth Circuit throws, in the non-citizen bar's face, the whole deficient NTA thing and Pereira, which I'll admit, seems quite on point for that academic proposition. And the court explains how the regulatory history is actually a bit blurrier, and that executive practice might not have been as consistent as we all thought it was over the 28-year period. Also, it seems to me, the Fifth Circuit explained that maybe the inconsistent treatment was a result of insufficient detention space in America, which is absolutely no problem anymore, given the explosion in billions of dollars dedicated to private immigration prisons in America today. Indeed, as of the date of this recording, it is being reported that ICE is about to spend $38 billion, with a B, to make warehouses throughout the United States into immigration detention centers. Plus reasons to court, this seems to be what Congress was getting at with IRIRA. News to everyone with a TV watching Minnesota, quote, the petitioner's fears about potential abuse of detention pending removal proceedings under Section 235b2a are wholly speculative, end quote. But all this is a bit besides the point of the Fifth Circuit. The text is what it says, explains the court, which is the most important part. And so, thousands get and stay detained in the Fifth Circuit. Judge Douglas wrote for 21 pages in a dissent that I will do if it becomes the majority in another circuit. But after some discussion, Judge Douglas begins with this. Quote, undeterred, the majority and the government distort the statutory text, abstract it from its context and history, ignore the Supreme Court's clearly stated understanding of the statutory scheme, and wave away the agency's previous failure to detain millions of non-citizens as if it were a rounding error. And for what? The majority stakes the largest detention initiative in American history on the possibility that seeking admission is like being an applicant for admission in a statute that has never been applied in this way, based on little more than an apparent conviction that Congress must have wanted these non-citizens detained, some of them the spouses, mothers, fathers, and grandparents of American citizens. Straining at a gnat, the majority swallows a camel. I dissent. End quote. Powerful stuff. Judge Douglas concludes by stating that, quote, the government's proposed reading of the statute would mean that, for purposes of immigration detention, the border is now everywhere. That is not the law Congress passed, and if it had, it would have spoken much more clearly, end quote. But Judge Douglas does not have the majority. We press on in the immigration bar. Here's this to conclude the episode from someone whose opinion is much more important than mine. Ira Kurzban writes that this decision was issued within 2 days of oral argument at the Fifth Circuit. Ira believes that this is upholding the BIA and DHS's bizarre interpretation of INA Section 235A2B as expressed in matter of Hurtado, and that has resulted in the incarceration without bond to thousands of non-citizens who have been in the United States for years. Ira thinks the dissent's position got it right when it discussed the differences between an applicant for admission and seeking admission. And Ira thinks that footnote 14 of the dissent is correct and understands the legislative history and what Congress truly intended. We'll see what happens, guys. The fight is only just beginning. And that is Buenrostro-Mendez et al. V. Bondi et al.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode?
Oh.
Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.